Well, first, I guess we'll kind of do a little introduction for those who have joined us before. We've done this quiz show type 40 minutes of competence in the past.
Mhm.
Last time I was quizzing Ralph.
And this time, I'm quizzing Matt.
and I'm going head to head against the chat. That's kind of what we
correct.
put together
Yes.
against our attendees. Okay, so my answers are C, E, and F.
All right. Well, you will be happy to know if I can get the slideshow to advance here. I'm working on too few screens.
Yeah, I'm. You're leaving me in suspense.
There we go.
Okay. Okay. Yeah. So, I think whenever I read questions like these, I'm always looking for the keywords. And so when I was first reading through the question, um, business develop, like increase the business development roles jumped out to me because that feels like an ARE question. Like, what do you want uh, your like project architects to work on so that you're doing more business development? And but I had to keep reading, and I found that we wanted to take things off of their plate so that they could focus on business development.
Yeah.
And so after that, I think it's a pretty. It's funny that we see it on the screen like this, but there's actually this pretty solid line
Yeah.
between things that require technical experience and things that are more
that
administrative.
you can hand off. Yeah,
Yep.
totally. Chat did get this one correct. We've got 65% answered C, 80% answered E, and 74% answered F. So that's above 50, well above the line. And there's a clear break between the correct answers and the incorrect answers there. So all of these questions that we're covering tonight are from NCARB's PCM practice exam. So you'll see a lot of practice management, how you run the business of architecture kinds of questions. And just briefly, the other thing, when I picked this particular question, the thing that was in my head is thinking about also what are things that are an architect's responsibility that you as the architect really need to have more direct responsible control over. You know, when we're talking about reviewing for quality control, when we're talking about coordinating with other design professionals, with our engineers, and even getting into the technical documentation to a degree there, as you said, talking about and thinking about what requires, not just what requires a kind of technical competence, but what requires the actual stamp, basically.
Yeah.
Is another thing that was a kind of part of the calculus there.
Definitely. Before we move on, I think it's a great time to plug that we just launched a course for the California supplemental exam. One of my big takeaways, Ralph kind of spearheaded that, but one of my big takeaways was how there's this big focus on responsible control. And I think that's when you're kind of thinking about during your tests, where you draw the line, how you're supposed to manage project, how you're supposed to manage people. The big umbrella term is, are you still able to exercise responsible control over that person? Which is where, I think it's a good way to think about these questions that come up about, how you interact with consultants. Are you able to exercise responsible control over their work? And therefore, can you reasonably accept liability for their work?
Yeah. Interestingly, NCARB only talks about the correct responses, but they're talking about them from the perspective of what is easy to delegate. And that's kind of an interesting thing here. We're thinking about what are the wrong answers here and eliminating those as much as, and why those are the wrong answers, as much as we're thinking about the three that are in fact the ones that we want to be picking too.
Absolutely.
So that's an important detail. But this is problem solving, an expert's process for answering ARE questions, part 2. Welcome to 40 Minutes of Competence, number 204. And so again, here's the question we just answered. And we will now move on to our next question, which I think has been launched here now, it looks like.
Oh, I need a whiteboard or some sort. See if I can do it in my head. Okay, so 60 hours.
This one's got a little bit of math to it.
Yeah. I have time to grab a piece of paper. Oh, will you be so kind?
I will. There you go.
Thank you.
Scratch that out real quick. We'll try to answer this one at we'll say 6:15 to give folks a chance to do the math. You got your number?
I have my number.
All right.
And I see my number on the screen.
Hey, that's important.
Yeah.
It's always fun when you're answering one of these questions and you do the math and the number you get is nowhere near what is on board. And then you know you need to try again. But it's 6:15. So I'm going to end the poll. And I can say already that whether or not Matt got it right. Oh God, I'm gonna figure out how to go back here.
I think if you click, it only advances.
Here we go. There are little buttons. Look at that. Okay. Now I know that we won't have this problem going forward. So it is
that, which was, sorry, I never said it, but you can see that
he has on his paper here 12,540.
So and it sounds like the chat mostly got that.
Yeah, we are at 76%.
Great.
Answered B there. So that's great.
A little bit of a reveal ahead of time. So
yeah.
But I think this is a pretty straightforward question in terms of math, but I think the place where this could go wrong, there's no kind of special language in the question description, but I guess where you could go wrong is when do you add the 10%, right? So,
and what is the 10% added?
And what is the 10% added to, right? So, without including the 10% allowance for unknowns, we're looking at answer A, 11,400.
Yep.
But then when you add the 10%, which is,
your
1,140. Yeah. Or contingency or whatever.
Both.
Yeah, absolutely. So you get answer B. And I think too, if I this is a tough question, I would think, if you didn't get the number spot on, because all of the answers are pretty close.
Yeah.
And if I didn't know the answer and I was taking the test and I wasn't close, I would probably flag it and move on and save it to the end when I really had all my time left to work the math.
Yeah. Well, this is a fairly simple question as far as calculations go, at least to me, for what the AREs can have. There are several other questions on PCM that I didn't put in, partly just because in this environment we want you to be able to have time to work through it a little bit more leisurely than you might on the exam too. NCARB actually shows it as the cost per hour per person. So your price per hour for the project manager times the amount of hours per review times the number of reviews or shop drawings, the number of shop drawings being reviewed, and then for the principal, the number of site visits. And then summing those two numbers. So you're calculating for each person, summing them, and then adding the 10%. The main thing is you want to add the 10% at the end here on the top of everything else. But you could also calculate it as like number of things to be done. So 20 shop drawings times 3 hours, and then that'll give you the number of hours that the person is spending on it. And then you can multiply that times your cost per hour to get the total number. Conceptually, to me, at least conceptually in my head, even though they give you the same result, they're very different ways of thinking about the problem.
Exactly. And, the thing that's coming to mind to me is in most real world applications, right? You're probably both going to one of the site visits, or you're getting some support on the shop drawing. So I think it is helpful when you're thinking about how much someone's time costs to break it down individually and then sum it all up.
Yeah, absolutely. Right, let's see if I can. There we go. Okay.
Okay.
We've got another math problem.
And I did not get a glimpse of this. So this is going to be, so, and as a recap, we're 2 of 2. So I need to get a leg up on the attendees.
Well, you're running even with them currently. There we go. We're good.
Okay. Great.
We'll answer this one at 6:25. But a local school board contracts an architecture firm to design and document renovations to 2 wings of an existing high school building. The contract calls for a design fee of $500,000 with the following distribution. Schematic design gets 15%, design development gets 25%, construction documentation gets 35%, permits and bidding gets 5%, and construction administration gets 20%. The firm completes the design development phase when the school board informs them that, due to funding, the project will need to be constructed in 2 phases. Each construction phase will cover only one of the 2 wings, will start in May and finish in September, and will need to be bid and permitted before each phase begins. What additional fee should the architecture firm request from the school board?
What a nightmare.
Yeah, that's not what you want to show up to work and find out about on Monday morning. That's for sure. Okay. All right, Matt, what's your answer?
My answer is B, 300,000.
Oh boy.
No.
You got caught by Incarb's trick there. I will note that the Hive has actually done pretty well here.
I bet they have.
So the second most selected answer is in fact 300,000, but the most selected answer, and indeed a majority, was C, 125,000, and the reason is the wings are separate wings, so the construction documents that have already been completed,
the design development documents.
Excuse me. The way that they talk about it is that construction documentation will not change because the renovation areas are already separated, but you will need to do permits and bidding and construction administration actually twice.
Yeah, and I was seeing that in the question, and that does, in a way, it makes sense. But I guess where my head went was because that work wasn't completed, right?
Then it's yeah. And so their logic there is that the scope of construction documentation has not actually changed. Where the scope of permits and bidding and construction administration is now doubled based on the original design fee. And that's the kind of question that you've got to watch out for. One thing that catches my attention when I read it is we're talking about these wings an awful lot in this question. So like what is important about there being 2 wings to the question?
Well, and also in the question, they specifically say they will need to be bid and permitted. Like they
specifically tell you the 2 sections that get duplicated.
Yeah. And
the two phases.
I ignored that and tried to make my firm more money.
Yeah. There are worse things to do. Although, careful about the school board, as they tend to be on tight budgets and might start looking elsewhere.
Absolutely.
But no, I mean, that's one of the more challenging aspects of the profession. Sometimes I think is when you have a client that, for reasons within or outside of their control, has a big change to a project.
Yeah.
You've really got to pay attention when you are accounting for that as a leader in your firm, so that you are able to maintain a profitable firm, so that you continue to operate as a firm.
Right. Absolutely. I feel like I just missed a foul shot.
We have to throw layups in there somewhere, but that doesn't mean they'll always take.
Yeah.
All right. If one of you will launch our next quiz.
So the Hive has me.
The Hive has you beat right now. Yeah.
Okay. I have to.
So we have a small firm in the South wins a large water park project in the Pacific Northwest. The firm has decided that they will team with a firm based in the Pacific Northwest to deliver the project. Why should the firm from the South team with the firm from the Pacific Northwest? Check the 4 that apply. And this is another question that, like the last one, is kind of simple, but prompts, and especially like the first one, prompts some really interesting conversations that I think we're about to have.
My seat feels kind of warm.
We'll go here in just a second, but this is check the 4 that apply.
Ralph looked at my answer and then looked back at me with no expression on his face.
I'm terrible at poker, though. We'll give. I'm seeing 123 in. We'll give folks a couple more minutes. Remember, you're checking the 4 that apply here.
I'd imagine you could count cards.
I lose track. At a certain point, it becomes difficult to keep up with.
Mm-hmm.
I do really well with like strings of numbers under, say, 6 or 8 digits, but okay. We're going to end the poll. Matt, what's your answer?
My answer, if I was taking the ARE, is A, B, C, and D.
All right. Well, let's see how Matt did and how Chat did.
Yes.
Chat did also really strongly pick A, B, and C. Over 90% of everyone who answered picked A, B, and C. We are just under 70% that picked D there.
And how many picked E and F?
20% on E and 14% on F.
Okay, so pretty split there.
Yeah.
So reading through the question, my first thought is huge geographic difference, huge climate difference. Mm-hmm. So all the first 3, like the Chat thought, are all really applicable. Yeah. You want that local knowledge. In the case, it's a very different climate, so you're going to need their expertise there. And then being close to the project is often why we see firms team up, or what we also sometimes call the architect of record role. Mm-hmm. As I looked at the other 3, I knew maximizing profits was just not the right answer, because I think through the lens of the ARE, teaming up with another firm is
not about that.
Not as profitable as doing it yourself.
It's also not as profit driven as doing it yourself.
Right. That's a good point. This is a results focused question.
Exactly.
And then when we think about moving between D and E, when we think about this architect of record role, Though they are oftentimes aiding in construction documentation, and sometimes it's negotiated that they're the ones who are submitting for the building permit and things like that. It's something that would need to be explicit in the contract, right? And so because I'm not seeing anywhere in this question description that the firm that they've chosen to partner with in the Pacific Northwest is
taking that on for some reason.
And then the other thing, which I think is the ultimate clue, is they say a small firm in the South. So, and we know a large water park is a large project. So shifting the project responsibility and liability to a local firm, that would need to be negotiated. But as a small firm who just won a large project, that teaming up will increase your capacity during the CD phase.
Well, and construction documents is really when a lot of these local expertise aspects that are laid out in A and B really start to come into play too. Obviously, thinking about those kinds of things as you're working on the initial design is really important, but as you go to actually detail and lay out and specify, it becomes really much more critical to have an understanding of what's available, what's necessary,
right,
etc.
Absolutely.
But no, I thought this was a really kind of interesting question. Of course, NCARB talks about the firm in the Pacific Northwest being more familiar with local regulations and being more familiar with the local climate. And of course, having a team member in close proximity to the project site increases the design team's availability and decreases travel costs is the big one there.
Absolutely.
Having to have a relatively senior person flying diagonally across the country pretty regularly for contract administration, construction observation services, that's going to start to add up pretty seriously. And that would potentially impact profitability, just because so much of their time starts to be spent on this thing that's less profitable than if they're able to work on other projects. And then for D, the second firm will increase production capacity during the construction documentation phase because it's a second firm.
Yeah.
That means more people. But no, the shifting of project responsibility, my understanding offhand of the typical contracts in those situations is that at least some of the responsibility and liability will flow through, even in an architect of record situation, will flow through to the design firm. And then we already went over why F is not so likely to be an answer.
Right. I think too, where ARE questions are hard is that there's definitely a scenario where shifting the responsibility to a local firm is helpful, or that there's a way to organize this where it increases profitability. But so all of these answers have some viability, but because it's not made explicit through the sort of context of the question, and they aren't as clear or as strong of answers as the other four. That's why we don't choose them.
It's a good example of a pick the best options kind of question.
Yep.
That these are all what I would call okay.
Yep.
All right, next.
All right.
And we'll if you all will launch the quiz, we will cut it off at 6:45. An architect who is a sole proprietor carries $1 million in professional liability insurance. The architect wins a new building project that requires $3 million in professional liability insurance. For how long must the architect carry the additional professional liability insurance for this project? I'm looking forward to this one. This is going to be a fun one.
You've seen my answer?
No.
Oh, you didn't look. I think you saw my answer.
No, I didn't see your answer. I saw some of your notes.
Okay. Oh, right.
But I didn't see your answer.
It's unclear. Yeah, it's unclear.
We'll keep it open for 30 more seconds.
To kind of fill the space a little bit, I think what this brings to mind for me in practice is that it is possible that your authority having jurisdiction would set so your state, the state you're licensed in, would set the terms for your professional liability insurance. And at least some states might.
That's one way to think about it.
I don't know that for certain, but I know that oftentimes states do issue, like I said, we launched this California supplemental exam, but most states, when you're applying for licensure, have a kind of entrance type exam.
Some of which are more involved than others.
Yeah.
Sure, yeah.
And oftentimes it's going over things like this. What insurance do you need, and to what extent do you need it?
What the specific local laws of practice are for that state, typically.
Right.
What's your answer?
My answer is B.
All right. Well, the group, it was waffling there for a little bit. We were on the line, but the group, more than 50% of the group has answered B.
And
B is, in fact, the correct answer.
Let's go. Okay, so just to recap, was this question number 4?
This is question number 5.
This was question number 5.
This is question.
So I went 4 of 5.
Yeah.
80%. So I would pass PCM.
Yeah.
Okay. That's what matters to me.
That's yes.
That's what matters to me. Okay. So to talk through my answer a little bit, for the life of the building, we don't do that.
Yeah. We know that's wrong.
We could talk about really old buildings for a long time.
Is Brunelleschi still carrying?
That's what I was about to say. Like
for the Duomo in Florence,
that would be amazing. I'd love to see that contract.
Yeah.
So, and then so I know that that's out, and then we have 2 options. So we have 2 options that are exceeding past the construction of the project, and we have 2 options that are within the construction of the project.
Yeah.
And so until the completion of all design phases, good luck with that.
That's before most situations that would result in a claim on your professional liability insurance would ever arise.
Absolutely. And so we're choosing between B and D, right? And certificate of occupancy triggers a lot of things in our professional contracts, both that we're administering over and probably in the case of like payment from our client. But
it's a really important milestone of the project.
Absolutely.
But construction's not necessarily done even at that time.
Exactly. And for the most part, the kinds of problems that we see that result in lawsuits relating to professional liability occur after the certificate of occupancy.
It takes a little bit of time for the effects of weather on a building that should have been mitigated, that are a common result, a common source of a claim like that would involve your professional liability insurance. Take effect.
And we've talked about, we use this example in the course where we talk about that terrible disaster with the tie rods for
the Hyatt Regency in Kansas City.
Thank you. In that case, that definitely got a certificate of occupancy before that happened. And I think, though I don't remember the exact result,
everyone lost their license.
Everyone got in trouble for that one. But and I think that's part of the idea behind professional liability insurance, is that you're not just getting it across the finish line and walking away. You're designing a building that is safe to be occupied.
But typically, and I don't offhand, typically professional liability insurance won't necessarily cover the kinds of really gross negligence that something like the Regency collapse in Kansas City involved. but it does cover more typical what are called errors and omissions. This is errors and omissions insurance.
Yeah.
That people make mistakes.
Yeah.
Yeah. And so this is coverage for that. One thing that is kind of critical to understand for this question is that basically, offhand, every state has legal limits, statutory limits for how long a lawsuit can be brought against someone for actions that are ultimately breach of contract. It varies. Typically, you're looking at about 10 years.
Yep.
But it does vary pretty wildly state to state. I think there are a few states that are as low as 4 years. This is one of those things that all of these individual state check-in exams, I'll call them, that a lot of people do have to go through before they are able to get their license in their specific state will be covering. That's, I would expect, if your state has that kind of exam, expect to need to know what the statute of limitations for professional liability in your state are. And it's typically 4 to 10 years. So if something happens to the building, we don't expect the paint to last 10 years. We don't expect a floor finish to last 10 years necessarily. We don't expect, lots of these points of contact that are wear points for the building will need maintenance after 10 years. But if you are having structural problems, if you're having, your windows fail because they were detailed incorrectly, that's the kind of thing that you can expect a professional liability insurance claim against. But there is a limit to that. If the leak is not discovered for 10 years, then it did its job well enough that the client then doesn't have a right under the law to sue you.
Right. And oftentimes when these kinds of claims are made, there is a little bit of a dance that happens between, well, was it my fault or was it the person who installed
did I detail it wrong or did they put it in wrong?
Right.
And of course, then there's a bit of a question too about when you're performing contract administration, when you're doing site walkthroughs, that's the kind of thing that you might do a little bit of checking on.
Right.
And was that performed correctly? And that's these kinds of things, these statutes of limitations are why firms will retain records of their projects for quite a while too, because you must retain your records for the full duration of that statute of limitations so that if there is a lawsuit, you have the documentation to back up your side of the story when it ends up in court or whatever, when it ends up in arbitration.
You're talking about field reports,
exactly.
RFIs, correspondence. Yeah. Okie doke. Great. And that's our last question.
That is, well, I mean, that's our last question that I put together.
Sure, but maybe we can. Exactly.
Let's see what we got.
Yes, if we have any questions from the chat. Oh, nice. Looks like some great conversations happening.
Yeah. Do we have any questions?
There was one there where they're asking for us to comment on it. Maybe if we can jump to that. I think it was at the very bottom. Okay, up right where it says reply.
Answer to the first question. Yeah, we can do that.
Or is that actually the one though? Is that actually what the question is? No, I don't think that's actually the question.
More people doesn't mean more productive. I mean, but people are working 40 hours a week. Sure. If you have someone who's really bad at their job, but we're assuming you're teaming up with a professional firm.
I think that's, there's a lot of ways to think about that. Sometimes it is more productive. Sometimes it's less, but I think in the context of the ARE, I think we want to be assuming that workers are all competent. So adding more people is to our advantage. I don't think I've ever seen an type question about so and so is a really poor performer. How do you make them get more done? I mean,
I've seen a couple of kind of professional evaluation type of questions that are very kind of HR related.
Sure.
But then you're talking about a conversation between you as a principal and an employee.
Yep.
It's a one-to-one interaction. It's not, we're talking about some other firm.
Yeah. True.
The kind of premise is that the premise is certainly that all firms are broadly equal, even though we know that that's not the case in reality. But that's one of the actual realities of having a national model exam, where you are going over things that are the standards that are not actually the reality in the field, but that are often close and are the things that the reality of how we actually practice in the field are built off of.
Yep. And I saw some in the Q&A.
So yes, this is the answer to the first question.
It's the answer to the first question. Let's check the Q&A.
Statute of limitations versus statute of repose. One of those, and I'm going to get them backwards. I think statute of repose is the one I'm going to talk about first here. But one of those is how long an undiscovered problem can wait and then be discovered. And then the other is, once discovered, how long do you have to file a lawsuit before you have waited too long upon discovering the thing to file? If I'm remembering correctly, statute of repose is the legal limit on how long an undiscovered thing can sit undiscovered before it's just, we have to assume that this happened outside of the time that it would have. And then statute of limitations is, once the thing has been discovered, I now have, say, 5 years to file the lawsuit.
Yep.
There is a calculator on the exam. You should check out NCARB's practice exam and get to know that calculator a little bit.
Let's see. Okay, we answered. Okay, so for the school design question, why did we double construction administration? Is it based on time or scope, since each phase the firm will technically be doing one week? Okay, so I think the idea here is that I think oftentimes with the AREs, and I know that we did do a question here where we saw site visits in terms of hours, right? But I think the way to think about construction administration is that it's like appointments or visits, in terms of visits, right? And so if we're constructing 2 wings at once, we're though in theory we are probably on site longer, we are making double the visits.
I don't know that it's necessarily, I know it said April or May to September, but it didn't say May to September of the same year necessarily.
Sure.
But basically the idea is that after that basically at construction documentation, the project has split into what is essentially 2 projects, but that the scope of construction documentation hasn't actually changed because the project was already almost 2 projects as it is.
Right. That's a great point. Yeah.
But instead of taking one big document set to get permitted, you're now taking 2 smaller document sets to get permitted that are together basically the same as that original big document set. You can split them. And
instead of 1 certificate of occupancy, you're doing 2 instead of, so in CA, the easy thing to kind of associate that with is site visits, but there's a whole lot of things. There's like construction kickoff meetings and applications for payment and all that kind of stuff. So we are in effect close to doubling our tasks by phasing the project like that. I think, Ralph, you had started to talk about this a little bit when we talked about the you were talking about professional liability insurance. Sorry, everyone. I'm moving on to anonymous participants' question about additional insured for B101. So you were starting to talk about this with the professional liability insurance, where because it's errors and omissions, if the building collapses and you go to your professional, I think what you were saying was if you design a building, it collapses, and you go to your professional liability insurance and you say, hey, I owe 80 million for the building, and then like some people got hurt, so that's another 200 million. Your insurance company would laugh at you and say, well, go look at the fine print. We don't cover that kind of thing, right? But maybe you can speak to that a little bit more.
Yeah. So additional insured basically offhand basically just means that this is another, instead of you being the only person that can file a claim with your insurance. So like, let's say we have a problem with the building and it's going to cost $500,000 to fix, instead of the insurance company paying you and then you having to pay the people to actually fix it.
Yeah.
Typically the additional insured will be the owner of the building, and it's additional named insured usually.
Yeah.
But they are now an entity that is entitled to file claims with the insurance company themselves for claims that are within the scope of whatever your policy covers.
Yeah.
If it's outside of the policy, then that's still outside of the scope of the policy. But instead of the owner of the building having to go through you to necessarily file a claim, they can now go directly to the insurance company and say, hey, John's building did X. It's going to cost $500,000 to fix it. Pay up.
Yeah. Well, and so in a way, this is two questions, but the thing that I think is really interesting about that is we could think of scenarios where you would be inclined to add an additional insured, and there'd be situations where you wouldn't.
Well, and most of the time, that's going to be laid out in the contract.
Exactly.
That you are obligated to name an additional insured, which again will typically be the owner.
Yeah.
You can name anybody pretty much, as long as the insurance company will write the policy.
It's true.
But that's why Lloyd's of London exists. You can, if you're willing to pay enough, you can get insurance for literally anything.
What's the wildest thing you have insured?
I mean, I don't. My health. But no, I mean, like that's how you get policies for things like Beyonce's legs.
Did you get that from Lloyd's, your health insurance?
No, God. Beyonce probably did get her policy for her legs from Lloyd's though.
Yeah.
Like Lloyd's insured the Titanic.
Yeah.
But and how insurance works at that level is a whole other thing. It's not typically one person underwriting the policy. It's actually a whole bunch of people who are each responsible for, say, 5% of the total value. But for example, if a building collapses, whose insurance will pay first? The answer to that question is it depends.
It absolutely depends.
Is it the architect's fault? Is it the contractor's fault? Whose insurance will ultimately agree to take fault? Is it the owner's fault? You will often have the insurance companies then fighting each other to not pay.
Yeah, absolutely.
On and on. So like that's going to be case by case. And ultimately the insurance that pays will be the insurance for the party who is ultimately found liable.
Right. And oftentimes why those kinds of disputes end in settlements, because the lines get drawn and folks end up just kind of wanting to move on.
Yeah, exactly. Rather than spending the next 5 years fighting it out in court, you get some money now.
Yeah. And I just wanted to answer Hillary's question about our questions for PCM. Are there going to be questions that consider specific state regulations, or do they all consider national regulations? So the thing to kind of look at is that, or the whole sequence here is that NCARB has created a standard for testing the competence of architects and
practicing in the U.S.
Generally, et cetera. Most states, there's a tiny asterisk next to that because we're talking about, that California has its own supplemental exam, which we have a prep course for. Most states have adopted NCARB standards as their own. And then
mostly,
and that's why we've then you then see, for me, I've been licensed in 2 different states, and both states, when I applied for licensure, took an open book test essentially on regulations and things that were specific to those states that they found really important. But in the case of the AREs and the practice management exam, you will not see a question that focuses on specific regulations of a state.
Well, that question that we saw about statute of limitations is exactly as specific as I would expect any of them to ever get in getting into what the actual state by state differences are. All of the specifics will be based on the national models and standards that NCARB refers to when building out the ARE.
Yep. And I think we've hit time, right? We could answer this last question here. We got a question from anonymous participant. If code changes occur by the start of the second phase, and which I'm going to assume is, are we talking about the wings here? Maybe we're talking. Yeah, I'm going to assume that. And the contract specifies it's a lump sum. Does this mean the owner is responsible for the cost of a redesign fee and the general contractor's time? Making some assumptions here to just jump into it. But I think that's what's going on there is a change of scope. And so I think that what you'd have all the parties involved do, and this is how NCARB wants you to think about changes of scope. A change of scope is a timeout. We gotta renegotiate this thing. And so I would see a situation like that where, sure, it was lump sum, and it might still be lump sum, but we're probably drawing up new contracts if the code has changed. That being said, oftentimes if it's permitted,
that's where you might get a change order in. If it's permitted already, typically, if it's already permitted, those code changes shouldn't affect the project in most jurisdictions.
That's what I was going to say. So if we're talking about,
it was permitted under the existing code at the time.
Right. So
now, if you stop construction for too long, that can trigger, in some states, needing to then meet a new code, but you're basically re-permitting the building at that point anyway.
Yep. Absolutely.
Which is a little bit different animal, to say the least.
Yeah.
But all right. Well, that was a fun time.
Yep. Hope you all had fun.
And Matt didn't quite beat the hive, but it got pretty close there.
But I did pass my exam.
You did pass your exam, and that's ultimately the important thing. One thing that I'm always coming back to is that the AREs are a completely different beast from what all of the exams that you've taken throughout your life otherwise, for most people at least, are like. If they're pass fail, it's completely, they're pass fail, and retakes are fairly low consequence.
Yeah.
It's not like, failing a final. It's actually reading day here at Virginia Tech in Blacksburg. So all the students are out getting ready for their exams tomorrow morning.
Yeah.
But it's not like with a final where if you fail it, well, you're done.
Yeah.
It's much more like submitting documents for a permit set. If it doesn't work, you revise and resubmit.
Yep. Yeah.
And with that, good night and get licensed.
I'm sorry I closed your screen share.
No, you're good.
Thanks, everybody.